Welcome to the Yunusov Question. I'm your host, Polat Yunusov. I interview lawyers and judges. This show is supported by Yunusov Law Professional Corporation, my law practice. I have practiced exclusively litigation since 2011, and many of you know me or my work. Your referrals are safe with me. Thank you and enjoy the show. Hello, everyone. This is another episode of the Yunusov Question. My guest today is Earl Cherniak, and let me just start with a very brief introduction of Earl. He practiced law for more than 51 years. He has been a litigator.
Practice law. I'm still practicing law.
He has practiced law. Yeah, he's still practicing law. Excuse me, Earl. You're absolutely right. You're still practicing law. So more than 51 years of litigation experience.
And I got to correct you. This is my 62nd year.
Your 62nd year. Okay. So I remember this story.
I was called to the bar in 1960. 1922 is 62 years.
Yes, and I remember the story. So when we talked recently, a couple of weeks ago, at the party where the Chief Justice of Canada was and Murray Hannon, you asked me when I was born. I told you when I was born, and you said, well, I had been a lawyer for a long time when you were born. So that's how I know you practiced law for a long time. More than 60 years, a lawyer for more than 60 years. You were a bencher of the Law Society in the 90s and in 2000s. And you were commissioner of the Ontario Law Reform Commission. You are a fellow of both the American College of Trial Lawyers and the International Academy of Trial Lawyers. You received the Advocate Society Medal. You were a president of the Advocate Society. You were the first recipient of the Bar Association, Ontario Bar Association Award for Excellence in Civil Litigation. In 2001, this is interesting, you were appointed a member of the Federal Judicial Compensation and Benefits Commission as the nominee of the judiciary and served in that capacity until your term expired in 2007. And you were appointed independent counsel by the Canadian Judicial Council to inquire into the conduct of a Superior Court judge. So, well, obviously, judges trust you, and you have more than 60 years of experience. You are still very much a practicing lawyer. You are an arbitrator, a mediator. My first question to you is, do you still have an imposter syndrome?
You know, I know what you mean by an imposter syndrome, and I've often thought that some of the young lawyers and partners in my firm have the imposter syndrome, because it's easy, especially when you're a young lawyer, to think that I did well in this case, but nobody's ever going to hire me again because it can never happen again. I had a pretty good year, but it can't happen again. I never had that. I always had a pretty good idea where I was going and how I was going to get there. But I know that some lawyers, and maybe even maybe more female lawyers, have that. They don't believe that that they know where their next retainer is going to come from. And I tell people, you're a good lawyer. Word gets around. It'll come.
Yes. Well, I want to start by asking you about where you were born, and we will slowly get to how you ended up where you are today. Where are you originally from?
Windsor, Ontario. And it's interesting. I live in Toronto, but I was born and brought up in Windsor, and people to this day, when people ask me where I'm from, I say I'm from Windsor. I'm a Southwestern Ontario kid. I live in Toronto.
Do you think the fact that you're from Windsor made any difference to your career as a lawyer?
Well, I kid the people in my firm and elsewhere in the profession that were born in Toronto. who grow up thinking that Toronto is the center of the universe. Those of us from the sticks, from Western Ontario or elsewhere in Ontario, never occurred to us before or after, before when we lived in Toronto, that Toronto was the center of the universe. So, you know, I think growing up in a small town, and I was a young Jewish kid with a small Jewish community in Windsor. In those days was about 100,000 people. I think I had life experiences as a kid that helped me in my career. Now, you know, there's a lot of lawyers, men and women who were born in Toronto who are pretty good lawyers, and so I'm not sure how much difference it made where I was born. But you know, everybody is a product of their life experiences. I mean, if you've read Marie Hennigan's book, you can certainly get that impression.
Were your parents born in Canada, or did they come to Canada from another country?
No, I'm second generation. My parents were both born in Canada. My father was born in Windsor. My mother was born in Montreal.
Were either of them a lawyer?
No, no. My father was a businessman. He went into his. Somehow I lost my picture.
Yes. We want to see you.
Sorry, I don't know.
Yeah, there you go.
Okay, sorry. My father was a businessman. He was a retailer. He went into business with his father, who started out as an immigrant peddler and eventually started a store that became Cherniak and Company in Windsor. My father went into that business, as did his brother, and my father eventually ended up as a menswear retailer in a company called Stewart Clothes Limited.
Where did your grandparents come from?
Both sets of grandparents came from the Belarus part of Russia, or now Belarus area. My paternal grandparents emigrated before 1900 in the 1890s, and my maternal grandparents came to Montreal in the early 1900s.
Did you feel any pressure as a kid growing up and as a young man to become a lawyer from your parents?
No, never. You know, the pressure I had, to the extent there was pressure, my father very much wanted me to follow him into his business and expand it and make it even a bigger operation than it was. So to the extent there was pressure, and really there was no pressure. I know what my father wanted, but you know, I started working in the business when I was a kid, summers and nights and weekends and over the Christmas holidays, and I realized early in the game it wasn't for me.
You know, I'm looking at your CV, which you emailed me earlier, and I think you're at that stage in your career where you don't even mention your education in your CV. It's so long, it has so many pages, and I don't see anything about what schools you went to. Could you talk about that a little?
Well, I went to public and high school in Windsor. I went to university in Windsor and at the University of Western Ontario. Following my graduation from Western in 1956, I entered Osgoode Hall. I was in the last class that didn't have to take the bar admission course. We had a 4-year course with articling after the second year. And in 1960, June of 1960, I was called to the bar. And from May of 1960 to May of 1961, I clerked for Chief Justice McClure, who was the Chief Justice of what was then called the High Court, now the Superior Court in Ontario.
And where did you article?
I article with the same firm that I'm with now, Lerners. At that time, there was about 5 lawyers, and I was the 6th lawyer when I ultimately joined the firm as a lawyer in 1961. But I came back to London to article, and I articled with a small firm called Kaplan and Titulis in Toronto when I came back for my 4th year in Toronto. So I article with small firms, and I'm still with the Lerner firm. It's a little bigger now than it was then.
Lerners, is it then fair to say that you have been with Lerners for more than 60 years?
I article with Lerners starting in 1958, so I guess that makes it 64 years.
Has anyone who is living now been with Lerners longer than you?
No.
So you are basically the dean of Lerners.
I am the senior partner now. My partner Janet Stewart joined us in 1969, so she's been there a long time. She was the managing partner for many years, so Janet would be the second longest serving lawyer in the firm. She still practices in the firm now.
You've watched Lerners change over the decades, and I think you were also one of the instruments of this change. You affected some of that change. How has Lerners, which is a very well-known and extremely reputable firm here in Toronto and in Canada, how has Lerners changed over the decades?
I mean, I have to appreciate that the practice of law, the legal profession that I entered in 1960 as a lawyer, bears no relationship to with the way law is practiced today. But I said this in a convocation speech that I gave not long ago. If a lawyer practicing 60 years before I was called to the bar, say in 1900, was called to the bar in 1960, he or she, and it would have been a he because there were no she's in those days, he would have very little problem practicing in 1960 because the practice of law in 1960 was not very different. Trials were short. There was absolutely no technology, but a lawyer now, I mean, what lawyers have to do now in 2020 or 2022 is so different than the practice I entered that there's no comparison. So, you know, what we call the Seven Sisters in 1960, the big firms that are 500 to 1,500 lawyers. A big firm in Toronto, Osler's and McCarthy's and Blake's, was 25 lawyers. So have to appreciate, and no women. So have to appreciate that Lerners has simply changed with the times. Now, a lot of firms our size didn't make it. We made sure in our firm that we associated with very excellent lawyers who were committed to the practice of law. We were early adopters of hiring women and people of quality, no matter what their race was, and we thrived. And eventually, in the mid 1980s, I opened up a small office in Toronto as a pure litigation firm. Our London office is a full service firm, but our Toronto office is a pure litigation firm, and it's grown to 55 lawyers or so now, and we have satellite offices in Strathroy, Ontario, and Kitchener, Ontario. So you know, it's just but we had a philosophy of providing excellent service. If people had a defensible or a prosecutable legal problem, we took it on, and we tried to get paid when we could, but we would never turn down anybody that had a good cause or a good defense. You know, for the first 10 years of my practice, more than half my practice was criminal law. So you know, in my early years of practice, we were known as the firm for the little guy because the big guys would never hire us. Right now, we're a combination. A lot of the big guys do hire us, and the big girls do hire us, but we still act for the little guy, and it's still my philosophy. If somebody's got a good cause of action or good defense, we'll take it on.
So this is very interesting. You say that you acted for the little guy in the beginning of your career and you still act for the little guy. I'm really interested in this transition because if I think of some of your biggest cases, so for example, the classic, the law school classic, Whiten and Pilot insurance on punitive damages, or Lac Minerals and International Corona on fiduciary duty and duty of confidentiality. You were not on for the little guy in those cases. So in Whiten and Pilot Insurance, you were on for the insurance company. And in Lac Minerals, you were on for Lac Minerals, which was the senior mining company, and Corona was the junior mining company. So how did you manage to move from a little guy lawyer to counsel to some of the largest organizations and companies in Canada?
Well, in the early years of my practice, our firm represented one insurance company and one insurance company only, and that was State Farm Insurance. Their London office was in the same building that we owned and practiced in. No other insurance company would hire us. We were considered, even though less than half the lawyers in the firm were Jewish, we were considered a Jewish firm. Insurance companies didn't hire Jewish firms in those days, certainly not in London, Ontario. But but over the years, we developed a practice taking on insurance companies that eventually insurance companies said, Lerner's got some pretty good lawyers, and ultimately we hired people like my partner Kirk Boggs, who does nothing but insurance defense work, and we got a reputation, and I developed a certain reputation as a lawyer. If you look at the cases I did in the 60s, 70s, and 80s, a lot of them were in the Court of Appeal. A lot of them were high-profile cases. I was counsel to the Moran Royal Commission investigating the Metropolitan Toronto Police. So I developed a certain reputation and a certain reputation for appeals. So just a state pilot and Whiten, a pilot got severely and quite properly beaten up in the Whiten case, because if you want to go into it, I can talk a bit about why that happened. But they got $1 million punitive damage award against them for denying $155,000 claim in a house fire alleging arson when there was no arson. And it was very clear in that case that their lawyers could not possibly take the appeal, because the principal reason that $1 million award was given was the misconduct of the lawyers as well as pilot. So the pilot needed appellate counsel, and they hired me because I had a significant reputation doing appeal work, and that's how Lac Minerals. And I didn't take the Lac Minerals trial either, but Lac Minerals lost that trial, and I guess they decided that they wanted experienced appeal counsel to work with their trial counsel on the appeal. I had and still have a significant reputation doing appeals, and I got the call. So it didn't happen by magic. It just happened by the kind of practice I had and the kind of reputation that I had developed. And and clients, especially sophisticated clients, they if there was ever a time that the clients and the major companies only used one law firm, that time was long past by the 80s. The sophisticated clients, whether corporate or otherwise, started looking around for the best horse for the course.
You were successful at the Court of Appeal in the Whiten and Pilot Insurance Company case. The panel was split, and the issue on which the panel was split was the quantum of punitive damages.
That was the only issue before the court. I mean, we didn't contest liability in that case.
Right.
Pilot was clearly liable. The appeal was about whether the $1 million punitive damage award could or could not stand. Majority of the Court of Appeal reduced the damages to $200,000. Pretty good judges, Finlayson and Marvin Katzman. And John Laskin issued a spirited dispute or dissent, and would have justified the $1 million award. I mean, there'd never been a punitive damage award anywhere in Canada that remotely amounted to $1 million, $50,000, $75,000 tops, and most of them were $10,000 or $15,000. So it was pretty unusual, and the Supreme Court of Canada gave leave, and Justice Binney, with only one dissent, upheld the $1 million award. But the interesting thing is that while Pile Insurance lost that case, the insurance industry won the case because the criteria that Justice Binney laid down, which is still applicable today, is so hard to fulfill that punitive damages awards in insurance cases, or almost any other cases, are very few and far between. So the insurance industry succeeded in limiting punitive damages awards for evermore, even though Pile Insurance lost the case.
I want to ask you more about the Whiten and Pile Insurance case, and specifically the Court of Appeal stage of that case. What was the oral argument like? When you were making oral submissions to the panel, did you have a sense that Justice Laskin would rule against you? What was it like making those oral submissions?
It was it's almost 25 years ago. I mean, I've known John Laskin for many, many years. He and I litigated against each other. It didn't surprise me that he ultimately dissented. I mean, I guess if I would have thought about it, and I can't tell you, when I remember the argument, but I can't remember thinking, oh, John Laskin is against me. You know, to the extent I thought anybody might be against me, it would have been Marvin Katzman, who was one of the most sensitive human beings. He and I were exact contemporaries, and he was one of the most sensitive and lovely human beings that I ever met. So I thought he might have been more sympathetic to the Whitens than it turned out John Laskin was.
So John Laskin got it right, obviously, because the Supreme Court of Canada agreed with him ultimately. What do you think this signifies? Was this a big change? Was this a watershed in the law of punitive damages?
It was a watershed, but not for the reason that I think you mean. It was a watershed in the law of punitive damages because there are almost no punitive damages awards in Canada now. Because if you read Justice Binney's very impressive judgment, the criteria he lays down would be fulfilled so rarely, that the conduct would have to be so egregious in so many ways, that punitive damages awards, certainly punitive damages awards in the range of $1 million, are very, very, very rare.
Do you think this is an unintended consequence of Justice Binney's test?
I don't think anything Justice Binney wrote was unintended.
Understood. And of course, apart from that case, there is another classic law school case, and a case that many lawyers cite in their factums that I would love to talk about. That's Lac Minerals and International Corona. And you were on for Lac Minerals, which was this big mining company that met with this small mining company, International Corona. And then there was a lawsuit that was about a mine or land that could generate profits. There was an allegation of a breach of confidence. Do you think this case is mostly about breach of confidence, or do you think this case is mostly about fiduciary duties?
Well, it was about both. I mean, and although there was a huge record and a 55 or so day trial, ultimately the two issues were: did Lac breach a fiduciary? Did it have a fiduciary duty to Corona? And did it get confidential information and misuse the confidential information? Those were the two main issues, and at trial, Lac lost on both those issues. with a five-judge Court of Appeal. Lac lost on both those issues. In the Supreme Court of Canada, Lac won on the fiduciary duty issue, judgment written by Justice Sabinka, but it lost on the breach of confidence and therefore the remedy issue 3-2. You know, the key reasons were a one-page judgment by then Justice Lemaire, later Chief Justice Lemaire, who agreed with Justices McIntyre and Sabinka on fiduciary duty, found that there was no fiduciary duty, but he agreed with Madam Justice Wilson and Justice Laforêt on the breach of confidence issue and the remedy issue. So, you know, it was an extremely disappointing result because you know, the deciding judgment was a 4-paragraph judgment, 2 paragraphs in our favor and 2 paragraphs against us. But you know, but ultimately, Lac Minerals, what Lac Minerals is most usually cited for now is a fiduciary issue in which Lac Minerals won. Unfortunately, they lost the case, they lost the appeal, and they lost the mine.
You were not the trial lawyer in this case. You were only involved starting at the Court of Appeal, correct?
Yeah, and that's very common in my appellate practice. I mean, I certainly did, especially in the early years. I appealed the cases I lost, and was in the Court of Appeal on some of the cases that I won. But in later years, the reputation I developed as an appellate lawyer, I most often was hired at the appellate stage.
Another interesting thing about the Lac Minerals case is that your opposing counsel in the Court of Appeal and in the Supreme Court was Alan Lenzner.
Well, Alan Lenzner and Ron Slack, but they were trial counsel. They were successful trial counsel as well. And, you know, I litigated with those guys many, many times in many, many different cases. And they were very formidable counsel.
Are they approximately your age?
No, they're younger than me, but they're both retired.
Okay. You said that you litigated many cases against Alan and Ron. Can you tell us more about this relationship? They're both, as you said, formidable lawyers, very well-known lawyers in Canada. I really want to hear more about your relationship with them.
Well, I mean, and we were good friends. I mean, you know, I won't say that I had a perfect relationship with every lawyer that I litigated against, but I certainly, principally, I'm not sure who's calling me, but I'll get that later. But I mainly had a very good collegial relationship with all the senior lawyers, all the lawyers, junior or senior, that I litigated with, and you know, and Ron and Ron and Alan were no different. They were with McCarthy's for many years before they opened up Langston Slatt, and so they defended the the Act for the Canadian Medical Protective Association, acted for doctors in those days. I and my firm had many, many malpractice cases. So a number, certainly not all, but a number of the cases that I had with either Alan or Ron on the other side were malpractice cases, and you know they were hard fought, and we won some, we lost some, but you know I respected them. I think they respected me, and you know we would socialize. We were not personal friends, but we had, and I had with most of the people that I litigated with, a very collegial relationship.
You wrote in your essay that I recently read in the Boomer magazine that you stopped being a voting partner at Lerners at the age of 65.
That's true. You know, I saw the growth of the firm from the time I joined in 1960, when we were 5 or 6 lawyers, to where we were 17 years ago in in two cities. I never wanted to be the managing partner of the firm, but I always took a very significant role in partnership meetings and the future of the firm and the philosophy of the firm. But by the time I got to be age 65, and I was still at a very busy counsel practice, my arbitration practice was booming. I had just recently become a bencher of the Law Society, which I did in 1999 when I was 64, I guess. And that went on for 8 years. And I just had enough partnership meetings. And, I continued, because I'm still with the firm, I continued to take an active role in the firm affairs. And I gave advice to my more senior partners, sometimes when they asked for it and sometimes when they didn't.
The amazing thing to me is that years after you were 65, years after you stopped being the voting partner, you continued practicing law, but years after 65, you did one of the biggest cases of your career, one of the most influential cases for the legal profession in Canada. You did the Groia case, Groia and the Law Society of Upper Canada. How long did that case take?
Well, okay, and for Bill Groia, he started to defend Felderhoff, John Felderhoff, I think in 1996 or so, in the Felderhoff trial, which went on for about 8 or 9 years, started in 1999. So for Joe Groia, between about 1997 when he started to act with Felderhoff in 2018, it was 21 years. Joe Groia retained me in 2009, May of 2009, when not long after the Felderhoff trial finally ended, when Justice Wynne, in a 600-page judgment, found Felderhoff not guilty, and the Law Society, which had deferred doing anything up to that point, issued a complaint against Joe, a professional misconduct complaint against Joe, even this since May 2009, even though no one had complained to the Law Society, and the Law Society based its entire complaint against Joe on reasons of the Court of Appeal of Justice Campbell and the Court of Appeal in the Felderhoff judicial review cases that took place in 2003, 2004. So the Law Society did no investigation, whatever. They didn't even have a transcript of the trial, but they charged Joe in 2009, and Joe called me up. I knew Joe. I'd litigated against him once or twice. So, but I didn't know Joe well. We were certainly, we were colleagues, but didn't have much of a relationship. But Joe called me up, and certainly was the kind of case that I would take on gladly because it was so interesting. And Joe was such an interesting client. But that case never should have gone forward, because when I was a bencher, I had set up something called the administrative type review for cases just like that, which if it applied to this case, would have ended up in a private hearing and a one-page summary of that hearing. And the Law Society placed conditions on it that when I was a bencher had never been mentioned. So that didn't work. So fast forward to 2018, when the Supreme Court of Canada came down with its reasons in favor of Joe, and that was the first time that Joe had won at any stage. So I was involved for 9 years, May 2009 to June 2018, and Joe was involved for about 21 years. So it was a long while, certainly one of the longest retainers that I've ever had. But was interesting because we tried to quash the complaint. We lost. We lost before the Law Society hearing panel. We lost before the appeal panel. We got leave to appeal to the divisional court. We lost. We got leave to appeal to the Court of Appeal. We lost to the dissent. And we got leave to appeal to the Supreme Court of Canada. And Joe won 6-3. So it was a fascinating retainer, and I got to know Joe very, very well. We became and remain very good friends. I did my best to convince him to run for bencher because I knew he'd be a very good bencher, and he did, and he's been a bencher for 2 terms. So it was, and the argument in the Supreme Court of Canada was, I've argued in the Supreme Court of Canada more than 50 times, but that argument was one of the most interesting that I've ever done, and it was the first time that any of my family came down to actually see me appear in the Supreme Court of Canada. My entire family, my kids, their spouses, my grandchildren, and lots of friends came down to actually watch the appeal, and they got a show. It was one of the most watched live appeals that I can recall. It was a great retainer.
Why do you think that?
But I mean, so I was 2009. I was 74 years old, and why wouldn't I take that retainer on?
Yes, it's incredible. So this case took a decade, pretty much.
Yeah, almost.
Almost a decade. By the way, it's another great, huge historical case where you had Lerners LLP on the other side.
Well, I had Tom Curry on the other side. Tom Curry was with that firm, and Tom Curry acted for the Law Society all the way through. And I've said many times, I've told this to Tom, I thought he drank the Law Society Kool-Aid on the civility issue, and and up until the Supreme Court of Canada, he was successful.
I can't imagine what it feels like when you lose every step of the way. You lose at the tribunal, you lose at the appeal division, you lose at the divisional court, you lose at the Court of Appeal. What kept you going? Did you know you would ultimately win? And also, do you think that there are systemic reasons for why the Supreme Court of Canada overruled so many levels of court below it? Is there something that everybody should take away from this, apart from reading the reasons for decision?
Well, man, we could spend the whole hour on my views of how that case went as it did, and I went to the Supreme Court of Canada because the appeal panel had decided the case, and the Court of Appeal, a split decision, but Justice Cronk gave a 90-page reasons upholding the. Get the picture back here. Justice Cronk wrote 90 pages upholding what the appeal panel did on the basis that what they did was reasonable, and the courts had to defer. But it took her 90 pages to review the entire case to do that, and there was a 65-page dissent. So there was a difference of judicial opinion. So when I went to the Supreme Court of Canada, I had to get around the standard of review, because a reasonable standard review, as I'm sure you know, is very hard to upset, because courts give deference to administrative tribunals making determinations as long as they're reasonable. And Court of Appeal and 90-page judgment said it was reasonable. So I came up with a bunch of several arguments as to whether they were correct. I talked about access to justice. I talked about freedom of speech. I talked about I argued independence of the judiciary, independence of the bar, the importance of resolute advocacy, and of course I I did make the submission that the decision was unreasonable, and ultimately, and the argument went on that basis. And if you've ever watched the fascinating argument in the Supreme Court of Canada, all those issues, all those interesting issues, independence of the judiciary, freedom of speech, and the like, they're all canvassed in the argument. But if you read the reasons, and you read the majority reasons of Justice Moldaver, he decided the case on the basis that the appeal panel's decision was unreasonable because they had found that Joe had an honest belief in the submissions that he was making, and that he didn't make them in bad faith. And what they found was that the legal argument that he was making, he shouldn't have made because he was wrong. In the Supreme Court of Canada, Justice Moldaver said it didn't matter that the submission that he was making was wrong. And we all make submissions to the court that are wrong, that are not accepted. But the fact that he had an honest belief in good faith that in the submissions that he was making, and because the law on the particular issue was in a state of flux, he found the decision was unreasonable, and he got 5 judges to agree with him. And the only judge that paid any attention to the legal arguments that I made about the independence of the judiciary and the way law societies shouldn't interfere with how judges conduct trials was Justice Cote, who agreed in the result. So it's a very complex case. I mean, it's not easy to upset a 90-page judgment of the Court of Appeal where they found that the lower tribunal was reasonable. But to get back to the first part of your question, I mean, lawyers like me lose all the time, and when we lose, we appeal, and when we win, the other side appeals. So losing is just part of it. I've been practicing litigation for my entire career. I've lost a lot of cases, and I've appealed a lot of cases. And sometimes I win, sometimes I lose. So losing is just part of what we do.
Is it fair to say that you learn more from cases you lose than from cases you win? Do you think it's true?
Well, sure, that's obviously true, because every time I lose a case, I think of all the things that I should have done and all the things that I shouldn't have done, that if I'd only done them or not done them, the result would have been quite different. And sometimes I think of those things about 10 minutes after I step out of the courtroom. Every lawyer does that. The French call it the thoughts on the staircase, the escalier. But every lawyer learns a lot more from the cases that you lose when you analyze why I lost them. In most cases, had I done the things that I wish I'd done or not done the things I think I've done, the result probably would have been the same anyways. But it doesn't stop lawyers thinking that.
You practice law. You practice law for more than 60 years. You are, I don't know, are you the most senior member of the bar in Ontario today? Do you know anyone who is more senior than you?
Well, there's a couple of my classmates that are still practicing law to one degree or another, and a couple of them are actually older than I am. But I don't know the answer to your question, but there can't be many other people still practicing law after 62 years at the bar and at my age.
Lawyers, your opposing counsel today are probably much more junior than you. I mean, I'm sure there are no 20-somethings or even 30-somethings among your opposing counsel today, but I don't think there's any doubt that almost all of them are much, much more junior than you. Since they're so much more junior than you, what advice would you give to them as junior lawyers relative to you as opposing counsel to someone like yourself when they appear in court against you?
I mean, if you, I mean, I work now. Except for arbitrations, there were very few files that I'm fully responsible for. I work with more junior lawyers, and many of them are partners, many of them in their 40s, 50s, or even 60s. and some of them in my firm, and some of them are in outside firms that retain me. But the most important thing, and I certainly tell all the junior lawyers in our firm, the most important thing that you got is your reputation. So you can hard work, you can know a lot of law, and you can do all the hard work you want, but if you don't have a reputation for probity and for ability, and you're not going to get anywhere in the practice of law, certainly not with the courts. So the advice that I would give to young lawyers is work as hard as you can. Get yourself known in the profession, but remember, no client's case is worth affecting your reputation.
Well, this is powerful advice, and it certainly is very concordant with a lot of the things that other guests of the Unisolve question have said, judges and senior lawyers, and it's extremely valuable. I want to thank you for doing this interview. I hope as many junior lawyers as possible watch this, and when I say junior, they could be 20, 30 years out, but I think they can still benefit from listening to you, and definitely young lawyers and law students will find this very, very valuable. Earl, thank you so much. I really appreciate it, and I want to wish you all the best.
Just one thing.
Yes.
What you said. When I was a young lawyer, if the way the profession worked in those days, if I had a serious problem in a case, criminal case or an ethical problem, I could call up senior lawyers in the profession who didn't know me from a hole in the ground. And for instance, Arthur Martin, who was the leading criminal lawyer of his day, he would take calls from lawyers like me at 5 o'clock in the afternoon or 6 o'clock in the afternoon and answer their questions. And and I think that's something that people like me, or even more senior but more junior people than me, should be doing. And people can still call me. I have an open door policy in our firm. Anybody can come in and talk to me about anything, and anybody outside the firm can call me about anything. I answer my own phone.
That's amazing. Well, we're not going to publish your phone. Your phone is on your website, law firm website profile, so people can easily find it, or your email address. I always prefer when people send me email rather than call. Thank you. This is very generous, and it's good advice. Call senior lawyers, call Earl Cherniak, and I'm certainly grateful for running into you several times at various parties, and every time I talked to you, I took away something valuable, something important that I didn't know before. Thank you again, Earl, and I wish you all the best in your future career.
Well, thanks, but I wish you the same. It was a pleasure meeting you.